Why do we want to free Anderson for? Okay, Christine. So Zachariah Anderson is a case, one of my first cases I covered. So go check out the playlist. And absolutely, he should not have been convicted. I don't care what you think about his true guilt, whether he did it. Honestly, I don't care. The level of evidence that was against him was so minuscule that you, Christine, could be charged with murdering somebody seemingly at random with the level of evidence that they had against him. So we've been fundraising for appellate purposes and a bunch of other things. We've been doing a letter writing campaign with the Attorney General to open an independent investigation. There was a lot of shenanigans going on with the DA's office and the court system itself. It was really bad, really, 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 really bad. And when you have, 20 or 30 attorneys on YouTube looking at this saying this is bad, you know something's wrong. Because you can get one attorney in a room and have differing opinions. But 10 attorneys in a room, you get 10 different opinions. 20 attorneys in a room, you get 20 different opinions. When you get 20 or 30 attorneys in a room and they all say the same thing, something's wrong. So this was a sham of a trial. It should have never been brought before the jury. The juries do what juries do. But it should have never even gone in front of the jury in the first place, in my opinion. It was a really bad case.
And again, not even lawyers. Again, we are layperson. We could be the ones sitting on your jury if you are getting in trouble. And I haven't seen outside of LNC that people saying, well, it was a clear-cut case. And I thought LNC was 76 or 86% not guilty in that case. It was one of the ones where I was just so surprised that normally they hit it right with jurors, but everyone was saying this is fishy. This is not a fair trial, and it was just such a bad trial to follow, because we have seen shenanigans in other trials, but this one was pure shenanigans. There was nothing linking him to anything.
So I'm going to talk about John's statement here for a second, since we have time to kill. We have a defendant who lives an hour away from the victim. The only connection, tentatively, is the fact that the victim, who we don't have a body, disappeared, but was dating the defendant's ex at the time. Within the time frame provided by the state, he would have had approximately 10 minutes or so to commit the murder and transport the body out of there. It's not a lot of time to lift up a 230-pound man and transport him out of there. We have no witnesses identifying the defendant at the scene. We have no cameras identifying the defendant's vehicle or himself anywhere near the scene. We have no video identifying the defendant or his vehicle driving to or from the scene on the stated time. We have no cell phone evidence placing the defendant anywhere near the scene of the crime on that day. We have no DNA of the defendant anywhere in this bloody mess, not cleaned up crime scene. We have no DNA of the defendant, or the victim rather, anywhere on the clothes of the defendant, anywhere in the house of the defendant, anywhere in the septic tank of the defendant, or in this traps under the shower or anything like that where he would have cleaned up, except one spot on the surface of the D pillar in the back of the minivan, which could have gotten there any number of ways, because again, the defendant and the victim share someone in common, and that is the ex. Also, the children that the defendant has with the ex. Children go in and out of the house where the defendant is in there with the ex. One little speck of DNA is not enough to convict somebody. In my opinion, it's a horrible way to convict somebody. So again, no witness, no cell phone data, no DNA of the defendant anywhere around the scene, no video cameras, no nothing. One speck of DNA was enough to convict this guy. So, John, one speck of the victim's DNA One speck. That's enough to convict him. Then I am I feel scared for you, John, because you could be convicted if you happen to have someone's DNA drift across the parking lot into your car. That's scary to think about, John.
Well, and he's also talking about, he said they found the clothes of the defendant in the burn pit. That's not true.
Nope. Never been confirmed to be anything other than burning clothes. And again, this is one of those where your normal daily activities are used against you. He burns, Zachariah Anderson, the defendant, burns everything in the fire pit. That was testified to. Yet because he had clothes in there while he was hiding something. It was tested.
My family burns clothes all the time.
Not all of the clothes were burnt by the way. So there were pieces of clothing left. They tested everything. Nothing. No human remains. Nothing. And also with regard to the missing carpet in the back of the old van, the lady that he was doing work for testified that he had taken it out before he started loading in all the scrap from the demolition at her house. So 2 days before the supposed murder, the carpet was already removed from the van.
Yeah.
And that was a shock to the DA because he was like, are you sure? And you could see him squirming because his whole idea is that he got rid of the carpet in the back of the van because it was covered with blood or whatever.
The van was dirty AF, so I don't know how.
It wasn't. The van was never cleaned.
Yeah.
So it makes no sense. The whole case makes no sense.
He said the witness lied. So.
Imagine simping that hard for gravy. Yeah. John, what does that feel like?
I'm trying to stay neutral like Switzerland because I've only watched.
He was trying to read his comment with Dave.
Okay, John, that witness lied. You believe that witness lied. I believe that witness told the truth. I believe the prison snitch lied. Mm-hmm. I believe Sadie Beecham lied. I believed OA was coached. You can believe what you want to believe, but still, it's not physically possible. It's not physically possible for the defendant to have been in that apartment and not left any DNA. They found DNA of unidentified males, but they didn't find any DNA of the defendant. It's not physically possible, John. It's not physically possible to drive down to Kenosha, commit the murder, and drive back in the time frame. It's not physically possible. It's also not physically possible to do that drive without getting caught on any cameras.
And
so
they couldn't
doesn't work, John.
And they couldn't do the DNA profile because they didn't have any of Gutierrez's DNA, and the family wouldn't help with a DNA profile because the dad was missing too, or something like that. So it's just
having a window on a video isn't stuff. Fine, convict him of stalking. I don't care. Convict him of stalking. First of all, it's not stalking because it doesn't line up with the statute. It needs to be more than it needs to be 2 consecutive or more times of following somebody and doing this. First of all, there was only 1, so that's not 2. And secondly, the victim has to know about it at the time. And knowing about it retroactively does not create fear back then. So, but okay, fine. Convict him of stalking. I don't care. It's not murder.
So I've just done the opening statements, and there's some contradictions, at least in Gravely. He expects you to simultaneously believe that Mr. Anderson is a super spy who is able to make an iPhone into a passive listening device and, a location device. Now, I am technologically just not smart, so maybe you can. But then he's also so dumb as to leave, all of the clues and stuff and, to bring his 12-year-old daughter into something. The 12-year-old daughter being used as such a valuable witness does not sit right with me. Because I can tell you, as having 12-year-olds, my 12-year-old wouldn't notice if a piece of carpet was gone. My
And I will
12-year-old
say
wouldn't
too,
know.
though, that they were, and it could be both of them were trying to use the child. I do a lot of divorce in my practice, and it's not terribly unusual for both parties to try to use a child. Did Zach try to use his daughter to, go knock on mom's door and play a prank on her, and this will be a cool little buddy thing that we have that mom doesn't know about, to kind of get in good graces with the daughter? Is the daughter being coached by mom against Zach? Prior to all the disappearance of the ex, they're in a custody battle, right? They're gathering information on who everybody is seeing. I do it a lot in my practice.
John, do we have the videographic evidence and all of the interrogations that they had with the 12-year-old?
No.
Because we've just got done talking that police officers can outsmart the... Look, I don't like that the 12-year-old was used as such an integral person, and we don't get to see exactly how these interrogations and forensic interviews were done, because this is how we ended up with a satanic panic. And
yeah.
But
yeah, I mean, it's just everything that Zach did is consistent with normal activity of working a job and being in a custody battle or preparing for a custody battle.
Yep.
So and then for that to be used against him and in such a manipulating way, like opening statements, and I believe even closing arguments, he went and bought bleach afterwards to cover up the crime. There was no evidence of bleach in the van.
Yep.
At all. And he didn't buy bleach. He bought bleach wipes, like disinfectant wipes, at the height of COVID, along with sardines and rubber gloves?
To hide the smell.
Deodorant.
Yeah, the sardines were to hide the smell. Yeah, that's right. And he parked way in the back so nobody would see in his car. Okay, well,
next to two other cars.
next to two other cars with other ones driving by. Okay.
He's got a dead body in the van. Like, come on.
Bullshit. It was bullshit.
And again, the girl suddenly remembering seeing a gun. The gun. Brought into trial, never mentioned before, and everything blew up because it was so clearly that Gravely, was that his name? He wanted to use that gun evidence in the case, and again, the die, all the things in that case were just, I don't want to besmirch the great DAs of Kenosha County, but it was just so bad. And for those of you who have never seen me before, I'm what's called a layman in Denmark. It's our jury system. We are elected for 4 years of the time. And I've been in a lot of different kinds of trials. Normally it's smaller violent crimes or theft or stuff like that. And I never seen anyone try to pull a fast one like they did in this one. Normally it's you keep to the facts, and everyone can see the facts with their eyes. But in this case, it was just talking about everything they didn't put into the trial as they put it into the trial. The closing arguments didn't line up with all the stuff they put in the trial. That's my biggest problem with that trial, is that he got away with lying so much in the closing arguments.
Well, as an
that's
officer
what
of
I
the
don't want to
court, I will
co-sign.
say we are held to a higher standard in integrity, especially when we are in the courtroom. And what Gravely did calls, I will call a question to his conduct, really. I guess I don't find it to be upstanding. I don't find it to be in the interest of justice. I don't find it to be in compliance with what the ethics rules require as an officer of the court. So that's what I have to say about Gravely.